Thanks everybody for coming today. Eleanor has a copy of the presentation that Ilana will be going through, as well as another set of documents related to what we're calling the 40B workshop materials. I'm going to turn this over very quickly to Ilana, but we just wanted to express we're grateful to have her here. Ilana Quirk is a specialist in the 40B area with our town council, KP Law, and so she is planning to go through an overview of how 40B works, maybe with some particulars to Nantucket. And I think the idea is she is open to questions being interjected as she goes along, and then she'll just kind of manage the process as she sees best. She does have a time restriction. I just want to make sure folks are aware that we do need to conclude by 4 p.m. So hopefully it's quicker than that, but I just wanted to mention that. Yeah. Without further ado, okay. Ilana.
Thank you, Tucker. I appreciate everyone coming today. And it is true, I do a lot of 40B work, sometimes 3-4 nights a week. And I totally understand that it's an issue that raises a lot of concerns with people, because the rules are complicated, the law is complicated, the case law is complicated. And so it is important, I think, to do a refresher course periodically. And certainly I did one, I think, in 2015. And it's been a couple of years, and it's just worthwhile to come back and do it again. This is a service that my firm feels very strongly about. We do this at no charge to the town, because we see the educational piece of this, both for the boards involved and for the public, to be a huge part of what we do and an important part of our job. Okay, so, and I have no remote or a clicker, as I usually refer to it as, which dates me, I think. So there are a number of issues with respect to what happens before an application is received. For the town, it's very important that the town reviews all of its regulations, its bylaws, and all of its local requirements. We want to make sure that they're all up to date. And I understand that staff is well underway with that process. And the reason for that is that the local requirements, the local regulations, local bylaws, only apply if they are in effect on the date that a 40B application is actually received. And so it's very important that they be up to date. And it's also important that the ZBA's rules and regulations include all of the necessary language to put it in the best position with respect to the imposition of consultant fees. And I know that Ed is here, over there. One thing that I just want to mention, the rules and regulations that the ZBA has are fine. They're well put together. There is one sentence, though, that I would recommend that be added, which is right out of the 40B regulations, which says that in the event that the reasonable consultant fees, that review fees that are imposed by the ZBA are not paid by a particular time period, then the application actually can be denied. And so that's an important tool to have in the regulations. So I recommend that the ZBA look at that. And of course, all of the fees that are imposed have to be similar and identical to what would be charged of a market rate project. And that's an overarching goal here and rule, which is that the 40B needs to be treated exactly the same as every market rate development, except, of course, that they have the ability to come in and ask for waivers, important ones, from the local rules. Okay, so the Affordable Housing Production Plan, there are a number of safe harbors. Most of you, I think, have at least page 1 of this particular document, which lays out the 7 safe harbors, which obviously are of great concern to the town when a 40B is actually before the ZBA. The first order of business for the ZBA on the opening night of a public hearing on an application is to examine whether there is a safe harbor available. And what is a safe harbor? A safe harbor is a ability to obtain the protection of one of either the statutory or regulatory provisions under, again, the statute or the regulations that say that if you've met a particular set of criteria within the town, then the ZBA would have the ability either to deny the relief or to impose conditions, even if those conditions would otherwise render the project uneconomic. The basic standard for review in the event that there is not a safe harbor available to the town is that when the ZBA receives an application and goes through the public hearing process, when they go to make their decision, they can only deny the relief or impose a condition that would render the project uneconomic if there is a local concern that outweighs the regional need for affordable housing, okay? And for which, even if that is true, for which there is not a condition or a set of conditions that could be imposed that would mitigate that harm. And you'll hear me say that over and over again because really that's the mantra that everyone needs to understand. That's the standard. In the event, though, that there were to be a safe harbor, then there would be the ability for the ZBA to deny or to impose conditions, and that determination would be found to be consistent with local needs, and there would not be the ability for the developer to appeal to the Housing Appeals Committee. And certainly, even in the event that there is a safe harbor that's available to be claimed, and certainly if there is one, certainly I strongly recommend that it be claimed, that the information be given out and that the proper notice be given. But there's also a concern, too, though, that a safe harbor most often is of very short duration. It might be a year long, might be less than a year. At most, it's going to be 2 years, unless you're over 10%, and really you're not close to the 10% mark at this point. And so what the ZBA and the town need to weigh is that you're trying, obviously, to get to 10% to make sure that affordable housing is created within the town. And in the event that there is a safe harbor that is available, it's certainly open to the ZBA to have the public hearing go forward and to negotiate from a position of strength with the developer with respect to conditions that the board wants to see imposed that would allow the development to go forward, but with conditions that the board feels are appropriate for the town. Okay? So you want to look to see whether there's a housing production plan. That's the first order of business. It's a two-step process. The first part of the affordable housing plan is to get it approved by DHCD, and that happened back in October of 2016 for the town, so you're all set as far as that goes. And the question that I always get about this particular provision is, well, we have an approved plan, so why don't we have a safe harbor? And the reason why you don't is because in order for the housing production plan to create a safe harbor, it needs to be certified. And in order to be certified, that means that production of affordable housing needs to happen within a calendar year once the housing plan has been approved. And there has been a request by the town for certification of the plan, but that has not happened as yet. DHCD, who's the Department of Community and Housing Development, has responded and said that they need more information. There are specific things that need to happen, and please know that staff is busily at work on that. All right? Okay, and the comprehensive plan, I'm not sure, yes, sir?
If there is a safe harbor, is the CBA empowered to impose conditions that say that the developer must build more than 25% affordable housing?
The ZBA would be in a position to impose conditions, yes, and negotiate from a position of absolute strength with the developer. Yes, sir?
Can I ask that everybody goes to the microphone? There's a lot of people watching from home.
Oh, sure. And to save time, because time is short, I can repeat the question.
Okay.
And so the question was, well, in the event that I'm paraphrasing, in the event that there's a safe harbor, how can the ZBA impose conditions, including potentially asking for a greater degree of affordability? And certainly, yes, the ZBA can have that conversation with the developer and say, well, in the end, we think that this is not appropriate, and we have the safe harbor. We get through the public hearing, we may deny, but also there's the ability to continue to have that conversation and a negotiation, knowing that that exemption is going to lapse likely in short order, and that they can come back without any kind of leverage on the part of the board, okay? So the comprehensive permit, the local comprehensive plan, in the event that you have a master plan that had specific issues for a particular property, then certainly that's something the ZBA can look at. I really am not familiar with all the ins and outs of your comprehensive plan. That's not something really that I was prepared to discuss today about. So the safe harbors. 10% is the one that you're probably most familiar with. That's easy enough. The 10% number is based upon the most recent federal decennial census. So right now, it's based upon the census from 2010. And how that is put together is that the feds go out and look at, in addition to the population, they look at the housing, and they publish numbers with respect to how much year-round housing there is within a community. And then DHCD uses that number to figure out what your total year-round housing stock is, and then the 10% number is pegged against that. And the eligible units to go on the SHI have to meet certain criteria. And the two most important ones are that there needs to be an affordable, affirmative, fair market housing plan, so that there's a lottery, so that the housing is distributed in a fair way, and there needs to be a permanent restriction on the affordability. So right now, Nantucket has only 121 units that are SHI eligible and on the SHI list. You need 490 units. You're only at 2.47%. But you do have a number of developments that are in the pipeline that are certainly helpful and in terms of making progress, both towards getting to 10% and towards perhaps getting certification of the housing production plan. The next safe harbor is the so-called existing development safe harbor, where 1.5% of the overall land in town is devoted to affordable housing. It's a very difficult one to put together. I've not heard any indication that you're close to that, and certainly it's been a popular one with a number of communities, and we've not seen one certified in that regard. The new construction exemption, in the event that 0.3% of the land has been devoted to affordable housing in a calendar year, that can give you a safe harbor. I have no information that you're anywhere near that. The next one, the recent progress exemption, which means that affordable housing units have been created within the prior 12-month period that exceed 2% of the overall year-round housing stock, and 2% would equal 98 SHI units. And then a large-scale project. A large-scale project depends upon the size of a community. And for Nantucket, based upon the overall year-round population, a large-scale project would be more than 200 units being proposed in a 40B development in order for essentially the ZBA to say, no, that's too large, you're past what we're able to absorb, and so you have the ability to say no. And I will say that I have seen many communities with this size project, that it is a large-scale project, where they choose not to say no, and where instead they have the public hearing go forward and continue to negotiate. Because oftentimes with such a large project, particularly if it is a rental project, then that all of the rental units in the event of development will count towards the SHI. It can be potentially a great way to move forward in the event that there's a project that's seen as worthwhile by the town to have that move forward, even though it is so large. Oh, yes, sir.
Are units bedrooms or individual units?
Very good question. Individual units. But certainly the bedroom count is of interest and always something that is of concern and kept track of. And in terms of conditions, it's usually pegged. In the event of the grant of relief, there will be a specific number as to the units and as to the bedrooms, number of bedrooms, and the bedroom mix itself, because that is very, very important. Yes? Oh, sorry. The question was, thank you, Ed, keeping me honest. The question was, for purposes of counting towards the SHI, is it the bedrooms that count, or is it the units that count? And the answer is it's the units that count. So the next safe harbor is the related application. In the event within the prior 12-month period prior to the receipt of an application, if the particular land involved has been the subject of applications for approvals, special permits, variances, subdivision, and if that application did not include at least what would be 10% of the units being SHI eligible, then there's a cooling off period, essentially, of 12 months. I frankly don't see that terribly often. We were invoking it right and left at one time, and so it's gone away. Everybody waits. They wait to come in, or they have negotiations ahead of time and try to set up, an exemption. And sometimes that works in the event that the project is well received. The housing production plan, as I mentioned before, was approved back in October of 2016. And it's not certified yet, but that is an ongoing process. You have a number of projects that recently received special permit relief to create local action units. But there's a process involved. The first step in the process is to get the units involved that are SHI eligible actually on the list, and there is a process for that, and that's ongoing. And when and if those units are sufficient in number that are added to the SHI, then there's the ability to move forward and get the HPP certified. If that happens, if there's production within a calendar year through the creation of SHI eligible units of 0.5% or 1% or more of the total units in the town. If it's 0.5%, you get a year's safe harbor. If you do 1% in a year, then you get a 2-year safe harbor. The difficulty with that is the DHCD interprets its guidelines, even though they seem to contradict the regulations, as meaning that even though you get a 2-year safe harbor, if you have 1% that you create in a year, in the event that the units lapse after a year, then they take the view that the certification will be withdrawn. And one of the reasons for my being here is to review how complicated these rules are. A SHI eligible unit means one that has received the relief that makes it eligible. In the case of a local action unit would be the zoning approval. In the case of a comprehensive permit situation, the issuance of the comprehensive permit. And then the way SHI eligibility lapse works is that once that approval issues and is filed with the town clerk's office, then the eligibility to go on the SHI exists for 1 year, for a 12-month period. And then the unit or units will lapse from the SHI and come off the list if after the end of the 12-month period, there is not the issuance of a building permit for the units. And then it will go back on, and you can ask again for it to go back on in the event that building permits are issued. And then once the building permit issues for a unit, it will stay on the SHI again for 18 months. And then if after 18 months there isn't an occupancy permit, then it comes off again. And then when the occupancy permit is issued, then at that point there can be a request to have the unit permanently added to the SHI. So that is a complicated dance, going forward to make sure that the SHI eligible units are captured when they need to be. And I know Tucker is working very hard on all of those issues. You have one person now who's really devoted to that issue. And any comprehensive permit that issues normally will have a condition, a boilerplate condition that will require the developer to cooperate with the town towards getting the units on the SHI. And that's necessary because, as you can imagine, everyone is very much aware when the comprehensive permit issues or when the zoning approval issues, but it's harder to keep track of when the building permit issues or when the occupancy permit issues. Developers very aware of that, but to have the back and forth between all the people who need to know in order to go and ask DHCD, that can be more difficult. So there is always a boilerplate condition that certainly I recommend be included in any comprehensive permit that's granted that requires that cooperation so that one hand knows, or every hand, because there are many hands, so all the hands know what all the other hands are doing. So in the event that there is a safe harbor available, then it's very important to know what the procedure is. Once the public hearing opens, in the event that there is a safe harbor available, the rules are very specific and they're very strict and, a bit difficult potentially to comply with. But the rules require that the ZBA has to invoke that safe harbor within 15 days of the opening of the public hearing. And so what I usually recommend is that at the opening of any public hearing by the ZBA on a 40B application, is that the first order of business is to review the safe harbor status, see where, go through all 7, go through them, very carefully, make findings as to each, and in the event that there is a safe harbor to be claimed, then go ahead, do it in writing. There's also a requirement that a copy go to DHCD. There is an appeal period that can occur. The developer, yes, sir.
So do we have 15 days to, you said we could stop this if we have local concern. So does that mean we have 15 days to?
No,
So that just keeps going.
the question was, if you have a local concern and you raise your local concern, does that stop the proceeding, or do you have to assert that within 15 days? And that's a different standard. In the event that there is a safe harbor, you don't need necessarily to get to the local concern stage at all. You simply have a safe harbor that you can invoke, and so then you don't need to have a local concern that outweighs the regional need for affordable housing that can't be mitigated. Instead, you invoke your safe harbor and say, you're denied, or more likely you would say, we'll go forward, but we may impose conditions. And those conditions, in the event that there is a safe harbor, will be upheld as consistent with local needs, even though there is not a local concern that outweighs the regional need for affordable housing. So that's a very good point. And so there is a bit of a complicated appeal process. Once the assertion of the safe harbor is made, the applicant has the ability to appeal to DHCD and say, no, there isn't a safe harbor, and then DHCD has a 30-day time period within which to act. And then there can be an appeal from what DHCD does to the HAC, and this all tolls the public hearing. Then there can be an appeal to the HAC. Then the HAC gives its ruling, assuming that it's adverse and they find that there is not a safe harbor, which can happen. Then it will go back to the ZBA, and that determination by the HAC will not be appealable to a court unless and until the ZBA acts, gives its decision, and in the event of an appeal to the HAC, until the HAC acts on the appeal, and then it all goes up at once. And importantly, burden of proof is essential in this particular arena, as it is in every legal arena. And I know that I probably have some lawyers out there, but I always like to review what burden of proof is. And the best example would be, there are 2 parties in a civil dispute. Let's say they have a traffic accident, they come to an intersection, and there's an accident and there's damage, and one party says the light was red, the other one says no, it was green, and they go before a judge, and the judge has to make a determination as to who wins. In a civil setting like that, the requirement is for the plaintiff to carry the burden of proof that it's more likely than not, 50% plus 1, just one increment, to get to a place where the judge says, all right, I believe that you have carried your burden. It's not a high burden, but it's more than 50%, that yes, the light was red and the other party ran the red light and caused you damage. In the event that the judge in that circumstance finds that both parties are telling the truth, they both perceived it the way that they're saying, no one is misstating the truth, it's just the way that they are looking at it, and the judge finds them both to be credible, that means you might say, well, there would be a tie. Well, there are no ties, and someone has to win. So in that particular circumstance, the plaintiff has the burden of proof, and because the plaintiff did not carry the burden of proof to convince the judge that, with all if things are equal, the plaintiff loses. So now you look at that in the context of a 40B. And let's look at it instead in the context of a variance. Most of you are aware of the fact that the burden of proof is very heavy on an applicant in the event that they seek variance relief. Very difficult statutory and local bylaw criteria to be satisfied. And in the event that the ZBA says no to the variance and there's an appeal, the burden of proof is extremely heavy on the plaintiff to appeal that decision. And I can tell you it's so heavy that I've never lost one. And it's not that I'm Clarence Darrow, it's just that the law is on my side when I go to deal with one of those things. Well, with 40B, the burden of proof instead is on the ZBA, and it's a heavy burden of proof. And if in the event that there is not a safe harbor available, then the legislature, and the courts have upheld it, have said that if there is no safe harbor, then there is a presumption, an extremely strong presumption, that the regional need for affordable housing outweighs any local concern that you could have. And therefore, there's
How about a local concern, like, say there's a development, a half a mile away from this development, and say the developer there has multiple lawsuits against him from people who have bought houses from him, and it took him 15 years and it's still going on.
we're not going to speak about
But I'm
specifics.
saying, like, would that be like, I just don't understand, like, say this was happening, would that be enough to, like, for cause concern for the, I just wanna know, how do you, like, if there are already concerns against this person, wouldn't that outweigh?
Well, I'm trying to get to that. So let me just finish. The local concern, the ZBA would have a very heavy burden of proof to show that there's a local concern that exists that outweighs that presumption, okay? And a local concern, I've got some examples obviously in the PowerPoint, and we can go through them. It'd be probably helpful for you to have them up there. Well, actually, they're too far up. We're getting ahead of ourselves. So the ZBA would have to find that there's a local concern that outweighs the regional need for affordable housing that is so important, the adverse effects are so important that they outweigh that presumption and that there is not a way to mitigate it. And when you look at someone's past conduct, and it likely is not the same conduct of the applicant who may be before you, every applicant is different. Every new application comes in with a new legal entity. The ZBA needs to look and see what are the local concerns. And the types of local concerns that we've seen in the past have included things like an airport runway is at the end, right at the end of where the project is proposed to be, and so the noise would be too much and the vibration would be too much. That was found to be a local concern that outweighed the regional need for affordable housing. And even with soundproof windows and so forth, it was found to be something that really could not be mitigated. Another example would be a incredibly long dead-end road, a mile long, with heavy, dense development that really raised serious emergency access for fire and for police in the event of hurricanes and so forth. So bottom line, it's very difficult to prove, and burden of proof is on the ZBA. And past conduct by someone, there's a basic zoning principle, which is that if let's say you even had the same entity, you don't ever do enforcement of your zoning through denial of a future permit. What you do is impose conditions that deal with issues that have come up in the past, and you address them through your conditions, rather than being punitive or trying to do enforcement in that way. Okay. So we went through
Traffic study.
Traffic studies are certainly something that the ZBA can inquire about and to ask for. That's a routine request in the ZBA's public hearing process to say, look, that's a very basic issue. We want to make sure that the traffic infrastructure works, but frankly, everyone needs to realize that the development itself is what's looked at, and in the event that the incremental addition to the local traffic conditions would not have much of an effect on already existing conditions that are adverse, then the project would not be held up for that. And that's another important point. The question was traffic, and can you require a traffic study? And the answer is yes, certainly you can ask for a traffic study. But one of the basic principles here is that if the ZBA looks at the local infrastructure, whatever it might be, the road, the water, the sewer, the ZBA looks to see whether it has sufficient capacity for the development to go forward. And there are two parts to that. One is that in the event that the infrastructure is fine for existing development, there's no problem with it, but the new development would create and would not be able to just tap into the infrastructure because it's too large. Let's say the flow of the sewage would be too great to go into the size pipe, then certainly there's the ability to say to the developer, well, you're going to have to put in a bigger pipe, or there's not capacity to do it, if those are the facts. But in the event that there's a problem with the infrastructure, where the infrastructure is ailing, then the case law is clear. That's up to the municipality to fix for all of its citizens, as opposed to a new situation that's created by the development itself. Okay?
I'm sorry, I have a question.
Sure.
So if citizens have concerns, who do they approach on the zoning board? Do they approach you, or do they approach Ms. Antoinette?
Certainly, when a 40B application is received and the public hearing goes forward, then what members of the public want to do is to attend, if they can, the public hearing, and they'll have the opportunity to listen to everything that goes on, and you have the ability to go and look at the file, and it's completely transparent. And if you have comments that you want to give, then there are two ways to do it. One obviously is to appear at the public hearing, raise your hand, be identified during the comment period, and make your comments and have a back and forth. Another way, which is important for the record, is to put your comments in writing. If you have a specific concern, if you're a close abutter. For instance, I often see in the 40B context, close abutters, usually across the street, who will come in and say, gee, this new accessway or one of the accessways is going to bring headlights, that are going to go straight out into my picture window or into my bedroom window or whatever it might be. And so it's a very specific concern that should be brought to the attention of the ZBA and the developers so that that can be dealt with. But those are the ways that the public can participate. Okay? Sure.
Quickly, because we have a lot of projects underway, on the island, and is there an overall map that does illustrate, those that are underway, those that are in the process, and then those that have an application forthcoming? So I think it, as a community member, it'd give me a visual of all these little mushrooms that are coming up. And then with that said, a traffic flow, so we can see that if all these were developed, how this is going to really affect traffic.
Well, certainly the town can look at traffic overall for the entire island, and that's worthwhile. But when the ZBA is looking at a particular project, it's only looking at that particular project. Now, if there is development right next door that's coming online, certainly they would have the ability to take that into effect. But the ZBA would not be looking at an overall impact. Certainly, they can say, look, we want to see a traffic study, and they can say, look, we want to see it out to a certain level so that they can see how the development is going to work. But all that the development is required to do is to deal with what it's going to add. And so if there's already an adverse situation, that's for the town to deal with. Yes. Eleanor.
I might, in response, downstream response to that comment and question. When the applicant does their traffic study, we generally have a peer-reviewed traffic study done, commissioned with experts in traffic. And they typically do downstream studies. So they would take into consideration other developments that are within a certain radius to kind of extrapolate what the downstream, so if you're dealing with something, let's say, that's at a major intersection, they'll look a couple of intersections down to see what the traffic impacts will be. They'll look at things like locations of schools and hospitals. So all of those things are taken into account when we have a peer-reviewed traffic study done, if they're not looked at by the applicant's traffic study.
Yeah, and this was not just in traffic in general, but just the overall, with that, the number of units each one's going to have, the number of the 40Bs, because we do have so many projects. And I know we're trying to reach that magical number of 490. I'm just trying to get an overall visual.
And yes, so the short answer to your question about the map with regard to projects that exist and that are in the pipeline at least as of a couple months ago. That map actually was created by the Affordable Housing Trust Fund last year and handed out before town meeting, and I can make sure that's up on the website, and it can now contemplate new information that we have received more recently regarding projects.
Question. On the 490, isn't that a moving target?
Yes.
All these other developments are coming on.
Yes, it's a moving target in that, as I mentioned at the outset, it's based upon the most recent decennial census. So in 2020, that number will change.
It'll stay stagnant until 2020.
Yes, it's based upon the 2010 number until 2020. Exactly. Yes, sir.
How far along these future projects that may happen with a traffic study, how far along do they have to be with the applications to be counted into this traffic study? If they haven't applied yet, it may not happen for,
It's not speculative. When someone comes in with an application, they need to deal with the existing conditions. And so,
there's no thought of future,
well, no.
just the future of the one project.
It's this project in relation to the existing conditions surround it, just the way that it would be for any market rate development. It would be the same. I mean, to speculate on what may happen in the future would just be too speculative, and so that's not the standard.
Responsible to make a traffic study happen, is that the zoning board or is that?
The studies first come from the developer. The request is made, the report is given, and then, as Eleanor mentioned, there would be peer review by a peer review engineering consultant by the ZBA, paid for by the other side, but it would be done on behalf of the ZBA and the town. And then the ZBA would look at the report and then look at the peer review. It is also possible for a town, if it wishes, and I've seen this in some rare circumstances, to do its own traffic study. And it may be that there's one ongoing in particular areas, and so it may happen to be there. And if that's the case, then certainly the ZBA can take that into account. Okay? So going back in time a little bit, just to talk a little bit about the project. Yes, Ed?
I have a quick question. On peer, or let's say the traffic study, ZBA wants to have their own traffic study done.
Needs to be funded by the, probably,
It'd still be fun.
well, by the board of selectmen.
Oh, so we would have to fund that.
Well, unless you can persuade the developer to do it voluntarily. Under the rules, they are not required to do so.
They are required to fund peer review.
Yes. Reasonable peer review, absolutely. And I have, as I say, in limited circumstances, seen a situation where a town has funded a separate traffic study, but that's usually, in unusual circumstances. So I've gone a little bit back in time here to the project eligibility letter. The first step in order for anyone to even come to the ZBA is to have what's called a project eligibility letter from the subsidizing agency. And what happens is that the developer goes and files the application with the subsidizing agency, Mass Housing, DHCD, and then there's a comment period that lasts typically for 30 days, or it can be extended, and it's often the case that it's extended a little bit for the town to make its comments. And then it goes back to the subsidizing agency, and the subsidizing agency looks at a number of things. It looks at whether the project is economically feasible based upon a pro forma that the developer puts together and submits as part of its application. And it looks to see whether the site is feasible for the design that's put forward. And during the comment period, the town has the ability to come back to the subsidizing agency and say, here are our concerns, here are our issues. Drainage is probably the number one issue, stormwater control, because most of these projects are quite dense, and so therefore they've got a lot of density, a lot of impervious surface. The percentage is probably far above, for most applications, what you normally would allow under zoning, and those requirements are there for safety reasons. And so the drainage has to be looked at to see whether the stormwater can properly be controlled. And what happens there is that the town normally would say to the subsidizing agency, please make it very clear that the developer need to provide what are called pre and post drainage calculations. And what that is is a set of calculations that looks at the existing conditions for the property with its soil conditions and with its existing vegetation, trees, plants, and so forth, and whatever buildings may be on it, and impervious surface that's already there, and then see what the drainage situation is right now in terms of the runoff from the property onto adjacent properties and onto any nearby road. And then there's a comparison to another report that comes out, which are the post-construction conditions that are anticipated once all of the tree cover is removed and the plants are removed, and once you add the impervious surface and add in landscaping as well, they get credit for that. And then they put in drainage basins or drainage structures. Sometimes they're underground, sometimes they're surface. Occasionally, you have a municipality, and that's not the case here, where there's actually stormwater infrastructure that a community may have that can be tapped into. And so the pre-construction drainage calculations are compared to the post-construction, and there needs to be no net increase in the runoff post-construction. And that can be difficult to do. And so that comes forward as two sets of reports that are put together by the developer and then by their engineer, and it's stamped, and so someone has put their seal on it. And then the ZBA has the opportunity to have that peer reviewed by their own engineer, who will look at it, will have software to run all the calculations and perhaps take issue with some of the underlying facts, perhaps take issue with the software, perhaps look at the various parts of the numbers and really parse through it very carefully. So that's part of what the project eligibility looks at to see whether it's feasible. But the technicalities of reviewing those calculations, that's left to the board to do, not to the project eligibility letter stage. So what happens is the subsidizing agency looks at the development, looks at the pro forma, and then comes back and says, well, this looks like it's economically feasible, it looks like the design is feasible, so we're going to give the project eligibility letter. Now, a frequent question that I get in forums like this is, well, can you appeal the project eligibility letter? And the answer is no, not at this stage. People have tried unsuccessfully. And the answer is that the project eligibility letter is only a preliminary determination. And so the courts have found that until the project moves forward and gets to fruition, you can't assail that determination. However, there are often, or sometimes, there are underpinnings to the determinations made in the project eligibility letter in the event of a denial of relief or the imposition of conditions. It may be that during the HAC appeal process that those project eligibility determinations may come into play. But the bottom line, for purposes of the ZBA review, it's not appealable at this stage.
Excuse me,
Sure.
is there any room for public comment during the project eligibility phase? Or strictly between the ZBA and the Mass Housing?
Well, certainly, that's a very good question. The question is, during the PEL process, the project eligibility application process, who has the right to comment? And certainly the town is given very specific notice, and the town will get together all of the different department heads, water, sewer, police, fire, DPW, the gamut, and give a series of comments. Certainly, if members of the public have an issue, there's no prohibition against members of the public giving comments to the town in order to pass along to the subsidizing agency, or writing directly to the subsidizing agency. There's no rule against it, certainly. So, how much attention will be paid will, I think, depend upon how specific the concerns are. Certainly, it's not a referendum. It's not a political thing, in the event that, an entire town were to come forward and say, we're opposed to this development. That's not something that the subsidizing agency would take into account. They would be looking at whether the project is feasible economically and feasible from a design standpoint, as opposed to people don't want it here, or they want it to be smaller, or, something that doesn't relate to the feasibility of the matter. Okay? Yes, Ed?
Part of the question I had was whether or not the ZBA was involved in that process. The ZBA is not involved in the PBL, project eligibility process.
No, that's the town, Because what's happening is when there is a project eligibility letter application, there's a comment period by the town. And so the town puts together a letter to comment, but the ZBA is, as Ed said, really not involved in that process because it's going to come to them eventually, but as part of the public hearing process. Lisa. That's a good question. The question was, when a PEL application comes forward, how do people know about it? And it varies from town to town. Some communities have a 40B website where that's all noticed. And certainly, when there is something new, certainly Nantucket has been, very open and transparent about, having me come and give a workshop to the ZBA and to the public on how these things work. We're not here to talk about any particular application, but whenever a new one is in the offing, it's important to look at the procedures that are involved, not in relation to that particular application, but to make sure that everybody is familiar with the procedures. Yes?
The town does have a 40B webpage. If you go to the town's website and in the search bar, literally just put in 40B, you'll see the page that comes up. And it has general information that we've received from the state through our town council. There's also specific project information for various different projects, but there's a lot of information.
Yes, sir.
When you have multiple 40Bs within, say, a mile of each other, do rules and regulations change for
No.
each?
No, not unless there's a safe harbor involved. And certainly I haven't. The question was, if you have multiple 40Bs in close proximity, does that change the rules? And the answer is no, it does not, unless there's a safe harbor that's involved. And certainly I have many towns where they have approved, numerous 40B applications, and then there's a requirement under the rules that at least for a certain period of time, and it's a long period of time, they've had to extend the life of those permits so that they have, a backlog that if it were all to be built, they would not just be over 10%, they'd be at, 15, 18, even 20%. But that's the way that it works. In the event that it's not built, you're not going to get to 10%. Yes, ma'am.
Does the state take into account that this is an island?
Certainly, any community that has a unique element to it, it should be taken into account. It will be taken into account with respect to the pro forma. Obviously, it's more expensive to build here.
Well, I'm not really talking expense, I'm talking about the fragility of the environment, or the limited, finite resources we have here, water, sand, materials.
Well, let's go back to what the standard is for the review of a 40B. It's whether there's a local concern that outweighs the regional need for affordable housing for which there would be an adverse impact that cannot be mitigated. And so what the ZBA would do once it gets an application is to look at the kinds of issues that you're talking about, but they would only look at them in the context of the approvals that are sought by the applicant. The applicant has the ability to come to the ZBA and have them sit as the comprehensive permit granting authority, and the developer can ask for the issuance by the ZBA of any local permit or approval. They don't always ask for all of them. Sometimes they are willing to go and seek the local approval from an individual board, but they can ask for all of them if they wish from the ZBA. And so to get to your fine question about environmental matters, in order for the ZBA to deal with those matters, it would need to look at the application of the local bylaws and the local regulations, and they would look at whether there's a waiver that's requested from anything that is a local requirement that is required to be applied, and then determine whether that local provision is so important that it rises to the level of a local concern and that it would be adverse to waive it and that there isn't a way to mitigate it. Then they could find that, well, that's a local concern that outweighs the regional need for affordable housing, and there is no condition. And so either there's a denial or they find that there is a condition and they impose it. We have some case law in this area the Stowe case, the recent Stowe case, Stowe versus Reynolds, where a ZBA gave waivers from a local bylaw that talked about nitrate concentration and found that, well, the state requirements, which all apply, state requirements continue to apply, wetlands protection, all of the sewage requirements, the state requirements all would apply. But in the Stowe case, what happened was there was a local provision which was found to be stricter than the state requirements. And so when the stricter local requirement was waived by the ZBA, the abutter appealed and said, I think that this is wrong. I'm afraid that my well will be adversely impacted by these higher nitrate levels, and I think I need the protection of that bylaw. And ultimately, the appeals court agreed and said, you're not going to get a new well. You need to have drinking water. You have to have that supply. It's a local supply, and that threat is not appropriate. And so it wasn't appropriate to waive that local condition. Now, in that case, they did find that while, ironically, the plaintiff couldn't show that there would be likely harm to his well, there was an abutter and was closer apparently to the potential flow, and it was found that it was likely that that well would be contaminated, and the court found that that was sufficient. So it's very specific. You need to have a specific bylaw or a specific rule that you have a concern about, and a waiver needs to have been sought from that requirement. And that's something else we should talk about, and I alluded to it a moment ago, which is that a developer has the opportunity in seeking a comprehensive permit to ask for all of the local approvals under the local bylaws and the local regulations to be acted upon by the ZBA. Sometimes developers will come in and say, well, I want a waiver of this particular permit. And the ZBA sits as the local permit granting authority and does not have to waive the need for the permit, but they can instead sit as that permit granting authority. And in the event that there are waivers from that specific permit criteria, they can act on that. But there's no need to just say, well, there's a local stormwater bylaw that requires that you get a permit. There's no need for the ZBA to say, well, we're just going to waive that requirement. Rather, they could look at it and say, all right, we're going to sit as that permit granting authority, give us all the evidence and tell us why you want the waivers that you're asking for, and then they act accordingly. And that's a really important point, because often a developer will come in and say, well, let's waive this permit and let's waive that permit. And I always recommend that a board think long and hard before it waives the need for the permit at all, as opposed to, okay, we're going to sit as that local permit granting authority, and you go through the necessary hoops to show us why you're entitled to that permit, or why it's appropriate to give you the waivers from the criteria that normally would be implied under that particular regulatory scheme. So, and that's just a very important point for everybody to understand, because the term waiver is bandied about, and certainly there's no obligation to waive the permit process. Okay, certainly when you get into the criteria under the permit, that's a different matter. But they don't have to waive the permit itself. So the 40B application has a laundry list of things that are required, and I won't bore you with all of it, but certainly, when the ZBA does receive an application, I will bore them with it, that there are certain things that need to be checked off. And you have great staff too, by the way, and so they go through all of those requirements as well, making sure that all of the elements are there. And one of the questions that I routinely get is, well, can the ZBA deny because the comprehensive permit application is not complete? And the answer is that that's just not likely to be the case. What the regulations specifically say is that failure to give one or more of the specific elements should not be a basis for denial. It's simply a basis to say, look, give us the information. In the event that there was something that was required under the list that wasn't met, and there was a continuing request for it and it wasn't satisfied, that would be different. But people certainly want to know what are the criteria that are required in order for the permit to move forward. And we do have some fairly recent case out of Hanover which says that in the event that the board has a reasonable fee that it wished to impose and the developer doesn't pay it, then there can be a denial for that reason. And Hanover did deny for that reason. The developer said, no, I'm not going to pay it. I think it's too much, so let's just go ahead with the public hearing. And the board said, we need the fee, and that was upheld. Okay, nuts and bolts of the public hearing process. Again, the reason for going over this is because this is a complicated thing. The ZBA is certainly used to doing special permits and doing variances and perhaps findings under 48 Section 6, but there are some differences. Obviously, the burden of proof is different, as I mentioned, and the standard of review is different, but the publication is the same, same as under 48 Section 11. And then there's some other requirements that are very specific to 40B. There's a requirement that the application, when it's received, that within 7 days of it's being received, the ZBA needs to, get that application out to all of the local boards so that they have an opportunity to comment. And they need to open the public hearing within 30 days of receipt of a completed application. But of course, I'm very conservative as far as that goes, and the ZBA is well aware of this, that in the event that there's an application and there's a question about whether it is or is not complete, my strong recommendation would be that it be noticed and opened within the 30-day period to avoid the potential for a constructive grant claim. And then you're arguing over, was it complete, was it not complete? I had one like that a number of years ago. Ultimately, the town was successful in bringing the developer back in, and it all went well in the end, except that it was a hugely expensive process. There were 4 different pieces of litigation. It was extremely expensive. And so my conservative advice would always be, even if there is a question about whether the application is complete, unless it's dramatically incomplete, that the board go ahead and open within the 30 days so as to avoid the expense of a potential claim of a constructive grant. And of course, it's always possible for the ZBA and the developer to agree to extend the deadlines. And if that happens, I recommend that the extensions be in writing and that they be voted on. And then, of course, they should be filed with the town clerk's office as soon as possible. The other deadline that's very important, and you see deadlines, obviously, in the subdivision context and in the variance and appeals contexts and special permits as well. But here we have a different deadline. The deadline is 180 days to keep the public hearing open. And so at the end or before the end of that 180 days, either the public hearing needs to be closed or there needs to be an extension. Otherwise, there's the potential for the claim of a constructive grant of approval, which again is expensive and time-consuming, and it's not a place that anybody ever wants to go. Everybody thinks, well, it's good for the lawyers, but it's not good for the lawyers. It's not good. It's not good. We don't want that. So you want to always keep track of the deadlines. And again, there can be an extension, and then once the ZBA closes the public hearing, there's a 40-day deadline to get the decision in. And the rules here are a little different from the other zoning relief that's out there. The vote has to happen within the 40 days, and then there's 14 days to file with the town clerk's office. I always recommend that the decision be done within the 40 days and filed with the town clerk's office so that there's just absolutely no question that it's done in a timely fashion. Again, always wanting to avoid even a claim of constructive approval. Copy needs to go to DHCD. And as I mentioned before, outside consultants are allowed. You need to know about the dance with respect to pro forma review, a question that routinely comes up in the 40B context as well. The economic feasibility and, whether a particular project would render the project uneconomic is an important criteria for the board to consider. In the event that there is no safe harbor, and in the event that the board has identified a local concern, the only way that they can impose the local concern is if it is a regional concern that outweighs the regional need for affordable housing and would render the project uneconomic, is if it's such an adverse local concern that it's justified and there's no mitigation that can happen. So the uneconomic aspect of a condition is important, because during the first part of the public hearing, the ZBA can say, well, we think that you should do this, we think you should do that, and then it may be that the applicant will come forward and say, sure, I'll do that and I'll do this. But in the event that they say no, and the ZBA has a condition that it wants to impose, and the developer says, well, that would render my project uneconomic, then that's when the burden of proof kicks in for the ZBA. And what the ZBA can do at that point, once the developer says, okay, that will render my project uneconomic, then the developer has the obligation to pay for peer review of the pro forma consultant for the ZBA. But until that happens, they're not able to look at the pro forma and have it peer reviewed, at least not at the developer's expense. And certainly there are cases out there that talk about the fact that it is not possible for the ZBA to look at a project and say, gee, if you would just reduce the project by 10%, that's what we want. No, that is not a proper criteria. What the ZBA has to look at is to say, well, we have height limitations, and we have setback limitations, and we have impervious surface limitations, and we have drainage issues. When you add all of those things up, and if they're reasonable concerns, that there'll be flooding, that there'll be, flooding off-site, that there'll be an increase in the discharge of stormwater over pre-existing conditions, well, then the ZBA can say that's a local concern, and we want to see, and then they say, well, you're going to render me uneconomic by making me adhere to all that, and then you can go through the process and say, show me the pro forma that you sent to the subsidizing agency and that was approved, and do a new pro forma. And the new pro forma is based upon the condition or set of conditions that the ZBA is looking to impose. And then the ZBA has the ability to hire an economic expert to look at the two pro formas and make a determination based upon all of the complicated financial criteria that are involved, and to give an opinion as to whether the condition or set of conditions would render the project uneconomic. If they would not render the project uneconomic, the ZBA may impose the condition. If they would render the project uneconomic, then the ZBA can impose the condition or set of conditions only if its reason for doing so is that there is a local concern based upon a local bylaw or regulation, other rule, locally, a concern about health, safety, and welfare that outweighs the regional need for affordable housing and cannot be mitigated. As I say, it's a tough standard. It's a tough burden of proof to make work. The other thing that you need to remember is that the ZBA, this is one of the only things that ZBAs do by majority vote. Some ZBAs do a Section 6, a 48 Section 6 nonconforming finding by majority vote. I probably have a handful of communities that do that. Most of them do it by special permit. But other than that, this is really the only thing that a ZBA typically does by majority vote. And that's by statute, saying that it is just a simple majority vote that is required, as opposed to the supermajority vote that you're used to seeing for special permits and for variances. Okay. So we've talked about this. Again, the standard is easily stated. In order to deny or to impose a condition that outweighs the regional need for affordable housing, the ZBA needs to find that there is a local concern that outweighs the regional need for affordable housing and that can't be mitigated by conditions. Again, strong, heavy burden of proof on the ZBA, and oh, okay. I don't remember this slide. Yeah, we actually already talked about this. Health, safety, and welfare is a concern. You have to apply everything equally. Again, a matter of fairness. Fair market housing goes forward. You have to do the same thing for the affordable situation. And the ZBA is going to want to be as specific as possible. And so the question from the audience before about, how do your comments get made? Coming to the ZBA's meetings, public hearings, public hearing sessions, very important, and putting it in writing is also very helpful in identifying, what the issue is, whether it's headlights or it's noise or it's vibration or a concern about stormwater or a concern about not being able to get in and out of a driveway. Whatever the concern is, being as specific as possible about it is very important. Contamination of a well, all very important issues. And in order for anyone to have standing on a private side in the event of the grant of a permit, the fact that there's a concern that there may be a diminution in property value, that is not an interest that 40B is designed to protect, and it will not give anyone standing to come in and appeal in the event that that's the case. So in order to have standing, an individual, and obviously that individual would have to get private advice. I can't give private advice to anyone, but just as a general matter, they will have to show some kind of adverse impact to their property interests other than a potential diminution in value. Again, the headlights, noise, not being able to get out of your driveway in some specific way, that the access ways don't line up properly. You're probably all aware that from a planning perspective, what the planners want to see and what traffic engineers want to see is that openings, if they're across the street from one another, that they come head on, so that when two cars come from the opposite sides, that the drivers can see each other clearly and can make the appropriate moves, as opposed to having them separated, but not by a good distance, in which case then one can come out and then the other thinks, well, I can come out too, and then you have a conflict. Yes, sir.
Is it mandatory that most 40Bs need two means of access?
Not necessarily. It depends upon the context, but certainly egress is always an issue. And the more dense the development, perhaps the greater need for more access. The real issue is the ability for emergency services to get in and out. And certainly one of the things during every review of a 40B is a request that there be truck turning templates that are looked at to make sure that the biggest piece of fire equipment can get in and can get out, that they have the turning radii. And the fire code certainly addresses the egress issue. The reason why I say sometimes you don't need any access at all. It may all be along the frontage, and so there is no driveway. It's just all, right up on the street, in which case the fire department has the ability to just stop in front and fight a fire, although they are going to want to get around in back. So not necessarily, but often we look to make sure that there are two means of egress. Absolutely. Right. We talked about this one. Outright denials, again, very rarely upheld. I've given you a couple of examples of when a denial has been upheld. With the length of the access road I mentioned to you is another one where it was very close to storage of hazardous material. Inadequate water pressure, very important. You have to be able to fight a fire, but that doesn't mean that there couldn't be a condition that could be imposed in way of a water tank or a standpipe. So you would have to look at whether that would work. I told you about the airport. Complete lack of open space, comprehensive planning if it's completely undermined. And I told you about the Stowe case. I think we covered all of those. And we talked about appeals. Modification requests. This is important for everyone to be aware of. You're used to special permits and variances and subdivision decisions, so that when a local permitting board gives a decision on one of those kinds of approvals, and then the approval takes effect and there's no appeal, or if there is an appeal, there's litigation, and then finally, the board is upheld, well, the conditions imposed are in cement at that point unless there's a change in conditions. If someone comes in after the fact, after the appeal period is run, and says, well, you had 10 conditions here and 2 of them I don't like and I'd like to undo them, the board then in that circumstance has the ability to say, well, no, you didn't appeal, and that's the condition. They can give it if they want to, but if they don't, and they say no, then there's an appeal, then you will see town council immediately swooping in to say that appeal is an untimely appeal of the original condition, and you should have appealed the first time around, unless there are changes in circumstance that warrant a new look at it, which is a bit rare. In the 40B context, and this is something that's very important for the boards to be aware of and for abutters and members of the public to be aware of, once the comprehensive permit is in place, a developer can come back and look at conditions that are imposed under the comprehensive permit, even though the appeal period has run and there was no appeal, and come in and seek to modify the comprehensive permit and say, look, you know, I need more density, or I need greater height. I need, instead of 2 means of egress, I'm only going to do 1, or instead of 3, I'm only going to do 2. And they can come in and say, look, this is an insubstantial modification. And then the board has only 20 days to look at that and to make a determination as to whether that modification is substantial or insubstantial. And if they find that it's insubstantial, then it's done. In the event that they find that it's substantial, then there needs to be a public hearing within 30 days. But you need to be aware that that's an important part of the process, because oftentimes you do see substantial modifications. So, certainly in the event that there are negotiations going back and forth, sometimes the abutters are talking with applicants, and if there's a concern, be aware of this modification process, and in the event that you are discussing terms and conditions and potential conditions that will be imposed and the developer agrees to it, you want to consult with an attorney as to how to preserve your rights, to make sure that there's a separate contract to deal with that, okay? Yes, sorry.
How would the public know when there's a comprehensive permit modification going on? How would we know when to slide in there?
Okay, that's a very important point. The requirement under the rules is that if a modification request is received by the ZBA and the developer has couched it as insubstantial, the ZBA has only 20 days to act on it, and they put it on their agenda, okay? And then they act on it once they get to that evening when the agenda is reached. There is no requirement for notice other than putting it on the agenda for notice to abutters and to the public beyond putting it on the meeting agenda. However, I'm aware that in Nantucket, there is a procedure that is typically followed, that when a modification request comes in, even when it's claimed to be insubstantial, that they don't have to, but they typically do notice out a public hearing within that time frame so that people are notified. Well, it's not required that there be a public hearing. It's possible to do one. And so that, I understand, has been the protocol that's been used. In the event that the question is, how do you see if a public hearing is noticed? And it depends upon where you are in relation to the project. In the event that you're an abutter or an abutter to an abutter, then you're going to get direct notice by mail. In the event that you're not, then it will be in the newspaper and it will be on the agenda. And I think Eleanor has something she wants to add.
I forgot to introduce myself earlier. I'm Eleanor Antonietti. I'm the zoning administrator. I don't know if this is working. And their contact for any comments that are ever submitted to do with anything specific comes to me via email and makes its way into packets or to the ZBA members in advance of a hearing. If in those cases where people choose or are unable to come to hearings. As to notification, when I receive a request to do a modification, if it's within a timely manner in terms of my publishing in the paper, I have my own deadlines to deal with, and sometimes they come in time, and I'll put that under other business or old business. And I'll put the specific language that the applicant is requesting to the extent necessary, approval that, or determination that a specific modification is insubstantial and therefore can be incorporated by default into the comprehensive permit. So typically those are things like, maybe swapping out a house model without changing the number of bedrooms. And typically that is not something that CBA considers to be substantial unless it has an impact on traffic or the parking arrangement is changed or something like that. I will notice that in the paper if I get it in time. If I don't, it will be on the agenda. So the agenda is always posted the Friday before the monthly meeting, which is always the second Thursday of the month. I do recommend that if you want to be alerted to any kind of ZBA hearings, that you sign up for alerts. Very simple to do on the town website. Just go on the town website and you'll be able to it's pretty simple, isn't it? I mean, I tell people to do it all the time. And if you need to know, just email me and I'll walk you through the process for doing that. But it's very user-friendly, the town website. And you can get alerts to planning board or any other board that you're concerned with as to any meetings and agendas. And you can open all those things up. So, or you can just check on your own. or you can check in with me. So,
And the other thing to be aware of is that the 40B regulations are pretty specific about providing guidelines as to what's substantial and what's insubstantial in way of a modification. And so if there's an increase or a decrease in the size of more than a certain percentage, then that will be a substantial modification. In the event that there's a change in tenure, which means from rental to ownership, from ownership to rental, then that would be a substantial modification. So there are a number of things like that. And obviously, there's also a concern if the development is moving around. Let's say there were a series of drainage basins, and they were found to be appropriate, but now suddenly, and I see this a lot, where, let's say there were 8 large buildings, and now they're going to consolidate them into 4, but they're going to be bigger. And so, which means that the footprints are going to be in a different place. In a circumstance like that, often a board, just for that reason, will find that a public hearing is required so that they can go through the drainage review process again. So there are any one of a number of reasons why a public hearing might be required, although it is also possible for ZBA to say, well, let's extend, if you're willing, applicant, the deadline for the determination, the 20-day determination, so that we can get peer review to see whether this is substantial or insubstantial. You know, it really depends. So it is important to look at the website and to make sure that you're aware of what's going on. And then the final thing that I wanted to mention is that, because I get this question all the time and it creates concern for people, the transfer of the permit. When someone comes in after a comprehensive permit is granted and says, look, we want to go from the applicant holding the permit to a new entity, that is very typical. I would say it happens probably 95% of the time, where a new legal entity is created to actually go out and do the development, different from the one that got the application moved forward. And the rules are very specific that a transfer of the permit to a new entity cannot be determined by the ZBA to be a substantial modification that requires a public hearing. But the rules provide that there is a requirement that there be a written determination by the subsidizing agency that the transferee meets the project eligibility requirements, that they're the right kind of corporation, that they meet the basic requirements that the original applicant was found to satisfy. And so, I often get that question, well, you can't transfer it to them, they're an untried entity and so forth. That is up to the subsidizing agency. And we have case law that talks very specifically and sternly about the fact that the jurisdictional issues that are within the purview of the subsidizing agency lie there and not with the board. And so that has to be respected. And certainly it's understood that the public will have questions, and it's very important to ask the questions, but that for that particular item is the answer. So that's the presentation. And so if you have any further questions, I'll be happy to try to answer them. Yes, sir.
This is just very basic. So the 10% is only based on the housing stuff. It's not based on other demographics like the year-round population.
Just on the housing stock.
Year-round housing stock.
Year-round housing stock, yes, which is important in Nantucket. Yes, ma'am.
Well, it's year-round housing. A house that somebody it's heated, but if somebody's only in it a month out of the year, is that year-round housing?
Well, certainly DHCD looks at what the decennial census puts together as to what's been determined to be year-round housing. I've never seen anyone try to challenge it. We did talk about it at one point, I want to say about 2 or 3 years ago, and I think the ultimate determination was that it was not something that could be challenged, that it had already likely been addressed. And I think it did go specifically to what you just mentioned, that it was the heat. The heat was the issue, if it's heated.
So Nantucket is considered to have a little over 11,000 discrete residences, of which 4,896 are considered to be year-round.
Yes, ma'am. The question is, who determines affordability? And that's an important question. And it's based upon the HUD guidelines and the regulations put together by DHCD. Okay, and so there are 2 types of affordability that we see, and one of them is a development comes forward with 25% affordability because the the maximum income for an eligible affordable user, either to buy or to rent, is that their income can't exceed 80% of the area median income as reported by HUD together with DHCD's regulations. The other kind of affordability that you see is where 10% of the units are affordable because the area median income maximum is far less, 33%. And I do see some developments like that, and occasionally it goes up even to 50%. But that's what drives that. It's not something that we have local control over. Very good question. Yes, ma'am.
They do not. They're restricted at 150% AMI. So to Alana's point,
Oh, you're talking about workforce.
this is the housing covenant program administered by Housing Nantucket.
Okay. Anybody else?
Yeah, I have a question about, people are always asking about whether there are any rules about the clustering of these developments. And evidently there are not locally or at the state. But my understanding is that the Supreme Court did rule disparate impact of affordable housing was a violation of civil rights according to the Fair Housing Act. And that was, I think, 2015 or 2016, a case in Texas. And I'm wondering, in the state of Massachusetts, if the conversation about disparate impact in the Supreme Court ruling has become part of the conversation at all.
I've not heard that raised.
How do we go about raising it?
Well, I think you just did.
I'd like to raise the issue of disparate impact.
Okay.
As upheld by the Supreme Court.
Okay, certainly, I don't know what Texas's rules are, but we have a very specific statute that requires a certain standard of review when you're dealing with affordable housing. So, I would have to look at the Texas case, which, I
Yes, obviously, I'm not a lawyer. I'm just someone who gives I care about the island.
absolutely. I appreciate your comment and consider it raised. Yes, sir.
A question about affordable units. Once a affordable unit is built, 20 years later, it's still an affordable unit?
Also an excellent question. What about the permanence of these affordable units? Until about 15 years ago, we had the expiring use problem, which is really what you're alluding to. How are they permanent? And certainly my firm has always required in our conditions that the regulatory agreement provide for permanent affordability with the ability for the town to enforce that. And up until about 15 years ago, that was not the case, but that is routinely the case now.
I guess my question would be more towards speaking of monetary value. Let's say a unit was worth $400,000. 20 years from now, it might be worth $600,000. And so if the affordable housing hasn't come up to that particular level, then is the 600,000, my old affordable house is now worth $600,000.
There are regulations that deal with that, similarly to the way that it's dealt with regard to area median income. You look at the rent requirements and the value of the property and the increases. But you raise a good point. I've not seen that come up over a 20-year span where there's a question about, obviously there's going to be some kind of increase. If you have an affordable unit, of course you would be entitled to some kind of increase over a period of 20 years. But it would be limited by your deed restriction, and the regulatory agreement would speak to that. Yes, sir, you had your question, you had a hand raised? Yes, we did. Yeah, just a quick recap, which is that, the housing production plan, it is approved, and it's been approved since 2016, and the certification of it is under review right now with DHCD. 24 to get a 1-year safe harbor, and it's either 48 or 49 to get, because if there's an increment, you go over to the next one to get a 2-year. I don't know.
Well, last year we had the units count in the year for which they were first eligible. So as of today, as Ilana had said earlier, our housing production plan is not certified. So we have roughly 18 units to add, let's say currently, but they're going to count in much earlier years, generally speaking, again, going back to the original eligibility date. I mentioned we're doing some further investigation into some of the more recent projects and when exactly they can count toward this. Sachems would be part of that 18 number. So there are 10 units in the Sachems project which would qualify for the shy list. Richmond is one of the ones we're investigating as to the exact timing of when they would come on. They've not sought building permits at this point. When Richmond, so we are presently at 121 units. We have the 18 that I just mentioned that could be added near term, generally counting in prior years. Richmond would add 242 units when they all were counted if it were developed as proposed. Six Fairgrounds would add 64 units. So at that point, we would be within 45 units of the 490 required.
Yes, ma'am.
Question about, in that vein, so when the building permit is issued or the CO is issued?
Okay, there are two issues. One is whether a unit is eligible for the SHI list, the Subsidized Housing Inventory List. Well, and so that's the first step. And they're interrelated, so you have to understand both. So the first step is to get a unit on the Subsidized Housing Inventory, and that will happen when they become eligible when the relief is granted in the case of a comprehensive permit, and then they stay on for 12 months after the comprehensive permit is issued, and then after 12 months they go off unless there's a building permit. If a building permit issues, they stay on for 18 months, and then they go off unless an occupancy permit issues, and if an occupancy permit issues, they go on permanently. For the HPP to be certified, there needs to be progress within a calendar year to make affordable housing eligible for the SHI for the first time. And so you look to see for comprehensive permits whether comprehensive permit is issued for the units within the prior 12-month period, because DHCD has stated we're not going to let it count again on the HPP when the building permit issues and then when the occupancy permit issues. It's only when it first becomes eligible.
So in this case, when we have COs issued for these 18 units, and we would like them to be put onto the shy list, so they will count at the time their COs issued,
Well-
because they weren't in that interim process?
Well, we're going to, the town is looking to have them added as soon as they can be, and as soon as they're added, then they count towards the HPP, okay? The problem with that is that if they don't get their building permit within the relevant time period, they can come back off the list and you can lose your certification.
So DHCD, so let's say we're here in Nantucket. We said 24 is a magic number. So you might think there was some advantage to kind of accumulating units and submitting 24 or more at once so that you would, hey, we're in safe harbor. But DHCD, other towns have tried that, and DHCD has said, nope, that's not how it works. The way it works is those units, so Sachems, for example, the comp permit for Sachems Path was issued in 2012. So when we add those units, we're gonna get 8 more units or 10 more units as of 2012. It's going to count toward, add to that 121 number, but it's not going to put us into a safe harbor situation today.
The rules are very complicated in that regard, to put it mildly. Yes, ma'am.
Can you just help me understand, in 2 years, that mean we need 490 more units?
The question is, what happens when 2020 comes around? And the answer is, the clock is, basically reset. And what the decennial census will do is say, well, you were at X number of year-round units in 2010, but let's say there's been an increase of 400 units in that prior 10-year period, then there would be a requirement not only that you reach the 490 that you needed to before, but you'd need another 40 units as well, even if they were all affordables. That's a public policy question for the state. Yes, sir.
Yeah, on that point, it doesn't seem to work for us. Is there any effort to change or modify the rule itself?
There have been a number of efforts to do that, including statewide, referendum that have failed. Yes, sir.
Do we have any sense of where we are with current numbers or houses, so we can anticipate how many more we're going to need to build in 2020?
Well, certainly if 24 rental units with at least 10% affordability were built per year, that would give you a 1-year safe harbor, each year that you did that.
Yeah, actually, that wasn't what I was asking when the census happened, the last, 2010, said 11,000 or so units. Does the town have any sense of how many units we are at now?
That I don't know. I would defer to Tucker.
Yeah, I don't know that I have a good answer to that. Anecdotally, you take some of the projects that we know are in the pipeline, such as a Richmond or a Six Fairgrounds, and you say that's roughly adding 300 units, and you're presuming they're all year-round units. You'd have to add 30 units as in regard to those units alone. But the other phenomenon that has been going on here is, which many people are probably aware of, is over the last 10 years, you've had a number of what previously were year-round homes sold into the seasonal / investment market. So those will actually drop our number. So I can't tell you where we're going to be on balance today.
And I apologize. I think I'm at the end of my allotted time. So I thank you all for your time and attention. Sorry, we should have done 5:30.